Welcome and thank you for joining Seyfarth's webinar, Navigating Derivative Claim Litigation, Insights from Leading Specialists. All participants are in listen-only mode. You are encouraged to submit questions throughout the program using the Q&A section located on the right side of your WebEx window. We will do our best to get to everyone's questions. Any unanswered questions will be followed up by email after the webinar. For those interested in CLE Credit, an attendance verification code will be read during the presentation. Please write this code down. It will not be repeated and is required for CLE Credit. Copies of the webinar recording and presentation materials will be distributed to attendees in the days following the webinar. At this time, I'd like to turn the program over to Greg Markell. Greg, you may begin.
Thanks, Sadie. This is Greg Markell. I am going to have the pleasure of introducing the panelists. We have a great group from all over the country and from various aspects of the profession, and I think they will be able to shed a lot of light on derivative litigation. First, I'm going to introduce John Favila. John is now at Berkeley Pro, D&O carrier. John joined Berkeley in 2013 and handles security class action claims on behalf of directors and officers of large companies. He also has extensive experience in handling and settling shareholder derivative actions. He's been in many mediations. He's spoken on a number of panels, including the Plus D&O Annual Symposium. And prior to Berkeley, John was at AIG for 17 years in a variety of claims positions, including managing claims group that were responsible for D&O and other claims. Next, I'd like to introduce Sarah Fedner. Sarah is a senior associate and my colleague at Seyfarth for 7 years, and we worked on a number of matters together during that time. She is a member of the securities litigation, commercial litigation, and ESG groups. She is also the New York office's representative on Seyfarth's Litigation Associate Advisory Committee. She has extensive experience in securities litigation, including derivative litigation, and in internal investigations, which we have spent a lot of time working on. She regularly presents and writes on securities issues and has been published in well-known securities outlets such as the D&O Diary. Andrew Escobar joined Seyfarth's Securities Litigation and Corporate Governance team in 2021 and is based out of our Seattle office. Seyfarth has a national presence in securities litigation and related cases like derivative cases, and that was enhanced by Andrew joining us from the Seattle office. He and Gina Ferrari have the West Coast covered very well, along with other partners on the West Coast. Throughout Andrew's 20-year career, he's written about, presented on, and successfully defended derivative cases in numerous jurisdictions and in a variety of contexts, including public companies, private companies, LLCs, and limited partnerships. So, as I say, I think this is a very strong panel, and we're going to have the pleasure of explaining derivative litigation to you all. I'm next going to pass this on to Sarah.
And I will have the pleasure of introducing Greg. This is just a little subset of his accomplishments in his experience in securities litigation. So Greg is the chairman of the litigation department of Seyfarth Shaw's New York office, and he is the co-chair of the National Securities Litigation Practice Group. He's a nationally known trial lawyer with vast experience in securities litigation, derivative litigation, and other complex litigation. He is a recognized leader in the profession and has for 20 years been highly ranked by Chambers for securities litigation. Greg was named by Best Lawyers as Lawyer of the Year for M&A litigation in 2018, And Law Dragon recently inducted Greg into its Hall of Fame and recognized him as a, quote, legend. He is also recognized by Benchmark as a national litigation star. He has chaired for 12 years the annual Securities Litigation Institute of the New York City Bar, and he is chairman of the Center for Corporate Governance at the New York County Lawyers Association. And with that, I will turn it over to Greg to get us started. Greg, I think you may be on mute.
I think there are some places to start with without getting into detail, which the panelists will do more of. But I do want to talk about what is derivative litigation. I'm sure there are some in the audience who know quite a lot about it, but typically, something like derivative litigation, which is unusual litigation. There'll be people who are doing this for to some extent as an educational tool. So we'll try to say things in the course of our hour that appeal to both groups. So derivative litigation is a type of litigation where a shareholder first should ask a board to commence litigation with respect to injuries to the corporation that they perceive to have taken place through the conduct of, could be board members, it could be officers, it could be others. But typically the party that would want to bring the lawsuit or be available to bring the lawsuit would be a shareholder. There may be some unusual situations where someone other than a shareholder, an equity shareholder, would bring these, but typically it is an equity shareholder. And they are, and you'll hear a lot about the demand requirement in just a bit. One is they are required, if they're a shareholder and not a board member, they can't bring a lawsuit until a demand has been made on the board to look into an issue that they have. It's important to understand that if there is litigation brought either by the board or a special committee or the original shareholder, that is litigation for the benefit not of the party that has pushed the litigation, let's say. It is for the benefit of the corporation. And so the lawsuit, if it is brought, would be for the benefit of a recovery by the corporation of an injury suffered by the corporation. And so that makes it pretty unusual, and it's part of the difference between a direct action and a derivative litigation. In a direct action, the plaintiff could well be the corporation itself. In a derivative litigation, it is someone else bringing a lawsuit for the benefit of the corporation. And that fundamental difference accounts for some of the things that will be covered today in explaining in more details some of the requirements that one has to have in order to be able to commence a litigation on behalf of the corporation. If it is not going to be the board has the authority, and you'll find out more about that in just a moment. But if it's not going to be the board, there's a demand requirement to be made by the shareholder or perhaps another party, but typically the shareholder on the board. And you'll hear a lot more about the demand requirement, demand utility, the requirement you may hear a little bit, we're not going to spend a lot of time on it today, about contemporaneous ownership, but that is another hurdle that has to be crossed in order to have the ability to go forward with derivative litigation. And there are questions at times about whose law applies, and there are a lot of different rules on that. So there are a lot of complications. It's a complicated area. I find it a fascinating area. And the final point that I would like to make, and we'll hear more about this later, there has been an increase in recent years in the number of derivative action filings, and there has been a noticeable increase in the number of large settlements to resolve derivative cases. So it is one of the reasons that we think it's important to let people know about how these cases work, what can be done from both the plaintiff's perspective and a defendant's perspective to deal with the cases, is because there are more of them, they're more frequent, they're getting more attention out there in the marketplace. And so it is important for people who are board members, officers of corporations, and shareholders and others to have an understanding, at least a general understanding, of derivative litigation. With that, and I'm going to pass it back to Sarah, who is going to talk about the role of the boards, corporate boards, and senior officers.
Thanks, Greg. So we are going to start with the roles and responsibilities of directors and officers, particularly their fiduciary duties. And you may be asking, why are we starting with fiduciary duties? This isn't a corporate governance presentation. This is a derivative presentation. There's a few reasons why it's really important to understand fiduciary duties in the context of derivative litigation. The first is that a lot of times the basis of the derivative claims are allegations that someone breached their fiduciary duties. The second reason is that oftentimes when a board is investigating a demand to investigate and possibly bring a derivative litigation, they are required to uphold certain fiduciary duties as well, including that they are independent, that they exercise care, and that they act in the best interest of the company. And the third reason fiduciary duties come up quite frequently in connection with derivative litigation is because of something called the business judgment rule, which I'm going to get into a little bit later. But as long as the board and officers have upheld their fiduciary duties, courts are generally going to defer to the decisions of the company and not upend those decisions. So in general, the board of directors has broad discretion in acting on behalf of the corporation and is the final decision maker, but their authority to act on behalf of the corporation is limited by these fiduciary duties. They can't violate those duties in acting on behalf of the company. They have decision-making authority in general, and when it comes to derivative actions, they are the entity that decides whether or not a derivative action should be brought on behalf of the company. They are allowed to delegate certain roles and responsibilities to other officers or committees of the board, usually as long as this delegation is clear, it's in writing, it's made in good faith, and there's some sort of oversight by the board to this delegated authority. It's completely acceptable. Boards of very large corporations can't necessarily be expected to handle everything, and that's why oftentimes they delegate responsibilities, which will come into play when we talk about officers' roles and responsibilities. Next slide, please. So the duties of officers are similar to that of board members, although in some cases they may be less broad or less stringent. It's clear that officers, in carrying out the duties that were delegated to them by the board, are required to uphold their fiduciary duties in doing so, including their duty of care and duty of loyalty. Officers are expected not to engage in self-dealing or act in a manner that may personally benefit them, but not benefit the corporation. There may be some cases where officers act in a negligent manner, and that could subject them to allegations that they breach their duties of care and loyalty, and in some cases, oversight. There has been a recent uptick in litigation against officers specifically. So more frequently, shareholders are trying to hold officers accountable, and there have been more and more allegations of violations of their fiduciary duties. Next slide, please. So I'm just going to go over, and I've mentioned a couple of them in describing the duties of officers and directors, but these are the four main duties that we think about when we're thinking of fiduciary duties by board members and officers. Next slide, please. The first main one that we focus on is the duty of care, and the duty of care requires that directors and officers of a corporation act in an informed and in a reasonably diligent manner in managing the affairs of the company. This could be codified depending on your jurisdiction. It is codified in New York. So if you're practicing elsewhere, I would double check. In some jurisdictions, it may be based on case law. Others, it may be per the statute. The next duty is the duty of loyalty, which generally requires officers and directors to act in good faith and in the best interest of the company and its stockholders. The duty of loyalty prohibits directors from acting in a manner that would benefit them, again, at the expense of the company. They're supposed to be disinterested and act independently. There is an exception to this duty of loyalty where there may be a situation where a board wants to move forward with a decision that may benefit a board member, or a board member may have a particular interest in. The company can still move forward with this decision as long as it's approved by a majority of disinterested board members, and these disinterested board members determine that the decision is in the best interest of the company, although there may be some benefit to another board member as well. So that's good to keep in mind if there's ever some sort of issue where there's a benefit to the corporation, but there also may be a benefit personally to the board members. The decision can still be ratified by a majority of the disinterested board members. Board members also have the duty of full disclosure, and this comes up a lot of times when there is something that has to be ratified by shareholders. In those circumstances, directors and officers have the fiduciary duty to disclose all material information to shareholders relevant to that decision. Now, that doesn't require the board or officers to disclose all information. A lot of times, like when there's a merger or some big decision, there's a lot of information that's considered before moving forward. And the board is not required to disclose every single detail of this information, but they do need to disclose everything that would be considered material to the shareholders' decision. So anything that could sway them one way or the other should be disclosed to the shareholders. In a case where perhaps the board realizes afterwards, we forgot to disclose this one thing, the correction should be made as soon as possible to avoid any sort of future liability, and the company should consider whether or not another vote needs to be held, given that that information wasn't considered by the shareholders in the first instance. And then the final duty I will cover is the duty of oversight, which has been subject to a number of recent cases, particularly in Delaware. The Martian case dealt with the duty of oversight in quite a bit of detail, as long as it along with the cases that came after. So if you are dealing with a case that has the duty of oversight as an issue, I would strongly recommend going to Marchand and the cases following Marchand. But in general, the duty of oversight requires that the board has some sort of reasonable oversight of compliance and risks, and that there's some sort of reporting mechanisms in place where information is flowing up to the board so they are able to assess when there is a material risk or some sort of non-compliance with the law. So there can be violations of the duty of oversight in two situations. First, if the board does not implement this reporting structure and oversight structure for compliance and risk, that could be considered a violation of the duty of oversight. Or if these reporting structures and oversight structures are in place and the board does not respond to a material risk that is reported upwards to them, this could also be considered a violation of the duty of oversight. But again, if you are interested in duty of oversight, I would definitely recommend reading the Marchand case. Next slide, please. So just to sum up, this is some of the responsibilities of the board. They are responsible for making all major business decisions that they have not otherwise delegated. They are responsible for overseeing the management of the business, determining business goals, allocation of resources, budgeting, and they are responsible for ensuring that the company has reasonable risk and compliance reporting systems that are overseen by them, as well as adequately responding to any risks that may be raised to them in accordance with their duties of care and loyalty. Now I'll get into the business judgment rule in the next slide. So the business judgment rule is a rebuttable presumption that is used by Delaware courts and courts in other jurisdictions as well, which in evaluating a decision by the board of the directors, the courts will generally defer to the decision of the board of directors. It's basically a presumption that the board of directors is acting in the best interest of a company, and the court doesn't want to disturb the decision of the board of directors because courts are not in the business of managing corporations. The board of directors are better positioned to understand the intricacies of their business, and they are better informed to make decisions for their company. So in general, courts don't want to disrupt those decisions. However, there are situations where the court may decide not to give business judgment deference. The burden is on a shareholder in a derivative case to show that business judgment deference should not be given to a decision by the board. This comes up if there was some sort of self-dealing, lack of independence. The board did not reasonably inform itself before making a decision. If they can show that there was some sort of wrongdoing in making this decision, which should take away this presumption that the decision was correct, then the courts will use a different standard, which is a stricter scrutiny. So the courts look at the entire fairness of what happened instead of just deferring to the discretion of the board and giving them that business judgment discretion. And again, the fiduciary duties back into this business judgment rule. As long as the board is upholding all of its duties, it's not doing anything wrong that the shareholders can point to, usually the courts are going to give this business judgment deference. And with that, I am done on my part, and I'll pass it over to Andrew.
Thank you, Sarah. So during the next segment, we'll talk about first, what is the demand and the demand requirements that are associated with it. And then we'll talk about demand futility and the considerations and the test that comes along with that. And the goal here is to both kind of look at what you need to do if you're on the plaintiff side and some of the considerations to keep in mind, And then on the flip side, if you're defending the company or the board or its officers and you're trying to attack a derivative complaint, what are some of the considerations and doctrine that you have to consider? So first off, the demand. As Greg explained at the top of our session here, there is a demand requirement that if a shareholder, and it's usually a shareholder, but it could be an LLC member, it could be a limited partner, if they want to bring a derivative action in the name of the entity for the benefit of the entity, they first have to make a demand upon the decision makers. In the corporation, it would be the board of directors. And they have to ask that board to take particular action. It could be to investigate a claim and then to pursue a claim. That's a key requirement. Now, the demand requirement may be excused, as we'll go into in a little bit, if the shareholder can show that making a demand would be futile. So why have a demand requirement? Well, I think we've all gathered already, and Sarah's excellent explanation there about the role of the board and what the board has to do. The board of directors, or in some instances, a majority of shareholder, has the decision-making power on behalf of the entity. As part of that decision-making power, that includes the decision to investigate claims, to bring a lawsuit. Sometimes there may be a valid claim, but the board's business judgment and its business judgment may determine that it's not worth bringing the claim, given the stakes of the issue. And the board, generally under its business judgment, would be entitled to have its decision respected. So when a demand gets made, this is a shareholder protection matter. This is where a minority shareholder, can have that right. If they think that there's an issue with the decision making or that something's going on, they can make a demand and bring it. And if the demand is not met, then if they go through particular steps, then that person may try to file suit in the name of the entity. Now, a couple key things to keep in mind, and we have it here on the slide, is that when you make a demand and then file suit, you have to explain in your complaint with particularity and specific factual pleading, what efforts did you make as a shareholder to secure or to try to pursue the action? When was the demand made? Why was it made? And then critically too, you have to explain why the board did not properly exercise its business judgment in considering the demand. And so this is important. You have to keep in mind that when you're on the plaintiff side, if you're representing, let's say, a stockholder, that if you make a demand and have your client, the shareholder, make a demand on the board, you are in essence conceding demand futility. You are in essence conceding that the board is independent and is not interested. And so really you're narrowing the scope to just the business judgment and whether the board adequately considered the demand and exercised its business judgment. And so this is key. For this reason, a lot of plaintiffs or plaintiffs' counsel will try to argue for demand futility if they think that they can meet the test. But again, we'll talk about that in a little bit. Next slide, please. So when you're considering the demand requirement and the test and the components of it, you have to consider the internal affairs doctrine. This is an important doctrine that, in essence, when you're litigating, those claims in a derivative lawsuit will be governed by the substantive law of the state or county of incorporation. And so that could be very different than the state that you're actually in. So the state I'm in right now, Washington, if we have a Washington or a company that's headquartered here, let's say in Seattle, they get sued in King County Superior Court in a derivative action. Washington law may not apply if that company, even though it's headquartered here, is incorporated in Delaware. In that instance, because Delaware is a state of incorporation, Delaware law would govern, and then the Washington court would have to apply Delaware law with respect to the fiduciary duty claims, the demand futility requirement. And then so that's important to keep in mind. So you need to know what state law applies, and to do that, you need to look at the state of incorporation. This is important because when either a shareholder is buying, an interest in the company or acquiring an equity interest in the company, you need to know what rules, kind of what the deal is. All right. So if I'm investing in a Delaware company, then Delaware law will apply. It gives certainty. It gives certainty to the mechanisms for corporate governance, and it gives certainty that if you have to litigate, what law will apply. One note, and this is an important one for the litigators in the crowd. If a derivative action is being pursued in federal court under state law, usually it'll implicate then diversity jurisdiction if the amount in controversy exceeds $75,000. And you judge that in derivative actions, given their special nature, by the amount at stake for the corporation, not the individual shareholder. So if the shareholder only owns one share in the company, I mean, that may raise a different issue, but if it only owns one share in the company, but the harm being alleged, the amount of stake being alleged, the liability being alleged is, let's say, $50 million, well, then, that arguably would meet the test for diversity jurisdiction. So, the takeaways again are these: know the state law, but then also know the type of entity involved. As Greg mentioned, at the very top, a lot of the cases we deal with will involve public companies, so easy enough. But and I know that we have some people who are affiliated with insurance carriers in the crowd. I've been on matters where there have been private companies, LLCs, limited partnerships that have all had D&O insurance that have been implicated by derivative actions. And so you do sometimes those LLCs or those limited partnerships, there will be specific state statutes that may change or modify what we're used to in terms of the demand requirement and some of the law involved. And so you do need to be aware of not just the state of incorporation, but also what type of entity are you dealing with and what are the potential nuances under the statutory scheme that's in play. Next slide, please. Another aspect is contemporaneous ownership rule. Anyone who wants to make a demand needs to make sure that they would have standing if they wanted to pursue a derivative action. And to do that, you have to be a shareholder in the instance of a corporation at the time of the act that you're complaining of and at the time you're filing the lawsuit. And many jurisdictions as well, you have to maintain that ownership throughout the life of the case. And so if you sell your shares or otherwise, maybe there's a merger and your status as a shareholder is extinguished, you can lose standing at that point as a shareholder plaintiff. The reason why this is important is because the courts and the policy want to make sure that it's a policy decision that you want people who have a stake in the outcome to be a plaintiff and to be a valid plaintiff in a derivative action. You don't want people buying into a lawsuit well after the fact in an opportunistic way, because again, kind of viewing it from a defense perspective, a derivative action essentially is trying to take control or hijack the authority to litigate. And so if there's going to be a determination on who has control over that, you want to make sure that there are valid stakeholders involved. And so this is a very important one. It's a fairly basic requirement, but if you're on the plaintiff side, make sure that your client lines up the right way with the contemporaneous ownership. And if you're on the defense side, you need to pressure test that and see what you can get. Now, many courts do not require the shareholder to be a stockholder of record. It's sufficient to be an equitable owner of the stock. In a number of jurisdictions, you do need to know your state law, and you do need to have that factual information available, both offensively and defensively. Another aspect too, and this is kind of part and parcel with the contemporaneous ownership rule, and you see this in the law, you see it in Federal Rule 23.1, which governs derivative actions, Delaware Chancery Rule 23.1. It's in the derivative action rule for most states and jurisdictions, is that the derivative plaintiff has to be a fair and adequate representative of the other shareholders or members who are similarly situated. That's in part, I think, informs the contemporaneous ownership rule, but it also, less so on the public end, so I won't dwell on it too much, but when you do face situations with perhaps LLCs or private, closely held companies, if the derivative plaintiff is a person who maybe is a former officer or has some shareholding that give them standing as a shareholder, but if they have a claim against them, if the company, if they engaged in alleged misconduct, and the company has a claim against them, you could actually knock out that derivative action by challenging the plaintiff's status as a fair or adequate representative. Like I said, usually not an issue for public companies, but if you are engaged in like LLCs or LPs or closely held company, keep that in mind. I've successfully actually this past year eliminated a derivative action on that basis. Next slide, please. So I think the theme you're hearing is not just know the law, you need to know the facts. If you're on the plaintiff side in particular, there's an expectation that you've done your homework. How do you do your homework? Well, for public companies, there's a wealth of information out there in the SEC filings and other public information. You've seen a push over the past decade and a half by Delaware courts in particular, really encouraging shareholders and their counsel to issue a books and records demand to help inform their complaint. And so if you're really gearing up for a derivative action and you go through the process of a books and records demand and you take that step and you put that in your complaint, it's not a requirement, but it can often give credibility, more credibility to your lawsuit when the judge is assessing any motion practice on like a motion to dismiss. So do your homework, use the tools available, and make sure that if you're on the plaintiff end, you are doing your best to meet that particularity requirement. And that's going to be especially important when we get to the next segment here, and that's demand futility. So next slide, please. So far more often than litigation, then we're facing allegations of demand futility when we're on the defense side, that the demand requirement is excused. Delaware has recently updated its pronouncement on demand futility test in a case a couple years ago. And there are 3 factors that are involved. And we have the test here. First, you have to do this on a director by director basis. It needs to be particularized pleading. And you have to allege first that the director received a material personal benefit from the alleged misconduct. And it has to be material. It can't just be a peppercorn. It does need to be something meaningful in connection with the alleged misconduct that would taint the director's ability to otherwise consider a demand. The second way to allege demand futility is to allege that the director faces a substantial likelihood of liability based on the claims that are the subject of the demand. Now, directors, a lot of times the companies will have exculpation clauses in their bylaws or articles. You want to factor that in because that could raise the bar on for liability. So if you're facing a complaint that alleges demand futility, you do want to look at that, and that's something to keep in mind. The third way to allege demand futility is to allege that the director lacks independence from the person accused of the misconduct. Oftentimes you'll see this it take a couple forms. You have to look at an inside director. So let's say on the board, the CEO is also on the board. The CEO draws a large salary, and if someone is accused of misconduct, let's say a major shareholder, the argument would be that the CEO is beholden to the decision making of the majority shareholder, their salary, their livelihood. That could taint their independence, even if the CEO, is not alleged to have engaged in the misconduct. For outside directors, it could be a little more difficult. The courts will look at the relationships between the outside director and the person accused of the misconduct. Often, let's say the chair of the board, and so they'll look at any potential financial issues. They'll look at relationships, but it really has to be more than just simply they were members of the same country club. You have to really kind of tie it in a bit more and explain why that director's decision making is sterilized for lack of independence, because they're not independent from the person engaged in misconduct. So a lot of these can be very factual. It is you may have, as a plaintiff, you may have this as to, let's say, on a 7-member board, maybe have it as to 3 directors, but you don't have it to the other 4. Well, guess what? If you can't show, any of these factors, and you only have to show one of these 3, but if you can't knock out these directors, at least majority of the board, you have an alleged demand futility. And so on the defense side, you want to look at that, you want to assess it, and you want to make sure that you can have strong arguments for why at least a majority of the board demand would not be excused under either of these 3 factors. So with that in mind, we'll go to the next slide, and we'll turn it over to Sarah for the crafting thorough responses to demands.
Yes, I'm coming off mute here.
And
So
do you want me to take it, Sarah?
sure, Greg.
Huh? You're
Yes,
good?
you can go
Go
ahead
ahead.
and take it.
I couldn't hear you.
You can go ahead and take it.
So the one thing I would add one thing to what Andrew said about those three items, and it would be this: one way of getting around. You can look at it as a way of getting around the requirement that a majority of the board have a defect. Is sometimes people go to a special committee and they get a special committee to where the majority or the entirety of the special committee is independent. I'm shortening the type of the three types, but a special committee is a way around, if you're on the defense side, a special committee may be a way of taking a board where the majority has one of the defects that Andrew mentioned, but also therefore is not, special committee can act with a delegation from the board of authority to as if they were exercising the judgment on behalf of the board. And Sarah, you may want to pick up there, talk a little bit about special committees. I don't know.
Sure. So on this slide, which we're going to circulate after the presentation, we have some bullet points in terms of what you should do in making a proper demand. But for purposes of time, I'm going to go to the next slide and actually the next one as well. Just talk about quickly when a demand is made. The board needs to determine, is there anyone who's interested in the underlying allegations? Because whoever is investigating and responding to the demand needs to be disinterested. They need to be independent. They can't be seriously implicated in whatever they're supposed to be investigating. So that's the first thing the company wants to do. It may be necessary to create a special committee because one member is conflicted of the board, or just because the board is overwhelmed and investigations into demands can be very time consuming. So it may just logistically make sense to delegate the issue to a special committee of the board. The special committee or the board wants to make sure to retain counsel to do a thorough investigation into the issue. And based on that investigation, which can include witness interviews, document reviews, etc., they want to make a decision that's reflected in board minutes and then craft a response to the demand explaining in detail whether they are deciding to accept the demand, deciding to refuse the demand, or accept part of the demand and refuse others. I want to get to damages, so I'll go to the next slide just very quickly. So if ultimately the company decides to refuse the demand, you're probably going to litigation either way, whether or not you decide to refuse the demand. If you decide to accept the demand, it is likely that the board will need to institute a legal action on behalf of the company against the alleged wrongdoers. If the board decides to refuse the demand, then it is likely that the shareholder who served the demand letter on the board will thereafter file a derivative lawsuit on behalf of the corporation. Many times these complaints and lawsuits that are filed will almost mirror the original demand letter that was sent to the board. And many times these cases are resolved at the motion to dismiss phase as long as the board or a special committee of the board did a thorough and independent investigation of the alleged wrongdoing and reached the conclusion that the derivative action was not in the best interest of the corporation. In general, that decision is going to be given business judgment deference unless the shareholder can come back and say, no one of the special committee members or one of the board members was interested in the decision. Therefore, there was a conflict and they shouldn't have been involved. If they can come back and show that there was some sort of serious issue with the investigation and the decision not to pursue the derivative litigation, then perhaps the court will decide not to give the business judgment deference. But in general, usually the decision to refuse the demand is given business judgment deference, and as such, derivative cases can be resolved at the motion to dismiss phase unless there's some other allegation that the board was not independent or participated in the wrongdoing alleged. And with that quick summary, I want to turn it over to John, or I think it's back to Andrew now. Yeah, Andrew, and then John for damages.
Perfect. And I'll keep this next segment quick because I think a lot of this has been covered by the presentation so far. But it really is just recognizing that, as we phrase here on the slide, it really is important. It's important when you're on the plaintiff side of the equation. Get your early factual review in. Really do your best to gather as much information as you can. You have that particularized pleading standard that you have to overcome. Details can win in that endeavor. Make sure you've done your homework. On the defense side, whether you're representing the company in facing a demand or when you're looking at the litigation, you really want to make sure you have a complete understanding of what went on, what is the issue involved. You want to look at whether there's any truth or at least apparent truth to the allegations, dig into that. And you also want to see and keep an eye on any conflicts as well, because conflicts oftentimes can be a major factor that can create some great difficulties in defending these actions, or lead to, and this is where I'll kind of bridge the next section, lead to some of the higher damages amounts or awards that have to that can be negotiated. So with that in mind, I'd like to turn it over to our final speaker here, John.
Thanks, Andrew. I appreciate that. Just one quick, so just to sort of set up my segment here, I'm going to be speaking from the insurer defense angle here. And to that end, and I know we had a disclaimer earlier for the lawyers on the panel, I have to give my own disclaimer that my opinions, and I've got a few of them, are not necessarily the opinions of my company, Berkeley Professional Liability. So they are my own. So when I say something weird, just don't call my boss, call me. So if we could just flip to the next slide. So what we're going to try and do here is just kind of talk about sort of where the rubber is going to meet the road, right? And it's always the same thing, right? It's always about the money, right? When you say it's not about the money, it's about the money, right? So we're going to start sort of here with defense costs and how much is all this stuff really is going to cost an insurer or a company. 220 demands. Andrew briefly touched on it. Oh, actually, Andrew briefly touched on Delaware. So from our perspective, we're going to talk mostly about litigation in Delaware because most of our public companies are incorporated in Delaware. So Delaware law is going to be controlling in a lot of these situations. So 220 demand, if we haven't covered it, is a demand for books and records by the shareholders. So it's under Section 220. It's kind of funny way that we say it. So when you get one of these demands for books and records, what do you need to do? Well, you're going to hire outside counsel. You're going to look at that demand. You're going to make sure that that demand is reasonable, what the scope of that demand is, how to formulate the proper response. And this is where the meter starts to run on defense costs, right? And most insurers these days, especially, which is kind of a change, are going to provide some sort of coverage for that. It's usually going to be some sort of a sub-limit below your regular limit, and it's not going to be subject to any self-insured retention. That's sort of where the market is going. For derivative demand investigations, right, as we talked about earlier, right, the company is going to initiate this investigation into the board for some possible misconduct. Right. Now, the company may appoint that special litigation committee that Greg alluded to look at that, and understanding that litigation committee is going to be completely independent of the board or independent really of the company. And that's really what you want. And as we sort of move forward, we're going to talk a lot about, independence sort of being really the linchpin of operating your business in this environment. And especially when you're facing litigation, you definitely need independence there. So what's that special committee going to do? They're going to decide whether the company should file suit against the board. They're going to give that advice. And as we all know in this phone call, advice is not free, so we're going to be paying for that. So there's a cost incurred with that. And again, most insurance policies, most public D&O insurance policies these days, you talk to your brokers, will provide some sort of sublimited coverage directly for that. And that's a benefit for the company, right? And as we move forward, we're going to start talking about what's the benefit for the company, what's the benefit for the individuals, and how the insurance policy is going to kind of address both of those issues. But at this stage, when we're talking about internal investigations, when we're talking about response to books and records, this is going to be stuff that is for the benefit of the company. So when we look at litigation, right? If we get that demand refused or demand ignored, right? We already talked about how the shareholder is going to file a derivative claim. Now you really need defense counsel. So now you're going to get defense counsel. Now and it's interesting, somebody in the chat asked this question about conflicts between the company and the individuals, and we're going to get deeper into that. But on this initial situation, right, the company is named as a nominal defendant. So the claim is made on behalf of the company against the board of directors with the company as a nominal defendant. So the company is going to need representation on its own. You're going to need separate representation for your board of directors, right? So you need different counsel for those folks. And if we take it one step further down, some of those folks may need their own representation, whether there's some sort of conflict. Maybe this is a former director. Maybe this is somebody who is dismissed from the company. They may have some issue there where they're going to need their own lawyer. And that happens quite often. And that's available to them. And so we're going to have this sort of separation between representation. Now, I have on the slide there a funny two words, indemnifiable loss. Again, derivative cases, we're going to talk about a loss that's indemnifiable, not indemnifiable. In this situation, defense costs in most states, including Delaware, the company is allowed to indemnify their individuals for defense costs and derivative actions. So that means they get to buy insurance for that, and that defense insurance is subject to the self-insured retention. So I think we're ready for the next slide. So here we are. So quickly on some resolutions and settlements, as the clock is ticking, I can feel it, but there's definitely some things that need to get out. So in the old days, right, and some of this derivative litigation, we dealt with mootness fee cases, tag-along derivatives, things that were almost kind of not really big, heavy things, and a lot of them came in merger objection litigation. So we'd have a merger objection case. Plaintiff's lawyer comes along and sort of does kind of a liquor store style stick-up job. That's what I like to call it. So they come along and say, hey, you guys need to make some extra disclosures in this merger. Company does it, and now the lawyer wants a couple of $100,000 fee. Well, in 2016, the Delaware Chancery Court said no mas on liquor store stick-ups, and in the Trulia case, eliminated those simple disclosure and mootness fee things. So those have kind of gone away, but we still see these 10b5 tag-along cases. And so how I like to think about it is like everybody's seen like, a shark swimming in the water and these little minnows hanging around that shark. Well, that's what our 10b5 tag-along cases used to look like. So we've got the big 10b5 cases, a big shark that's globbing up everything, and the little minnow is going to kind of tag along and see what it can eat. And at the end of the day, that little tag along case is going to say, hey, company, you've got to get some therapeutics in place. You've got to change your board. You've got to do business differently so this doesn't happen again. And when you do that, that's a corporate benefit. So for that corporate benefit, me, the plaintiff lawyer, needs to be compensated on behalf of my clients, the company. So those are still out there, and those are still kind of hanging around. We'll see those. That's those actually the majority of the cases that we see, these tag along cases. Then there's what we're going to kind of get into, cases where the minnow gets bigger than the shark. And I think the next slide, don't go to the next slide yet, because I want to warn people about this next slide. This slide comes with a warning. We're going to talk about a list of recent settlements, and it's kind of shocking. So folks, I don't want anybody to get upset. So we can go to the next slide, but I hope everybody's sitting down. This is an incredible list of recent settlements the last few years of derivative cases. All right, and now look at this list of companies. We know all of these companies. They're all household names, right? Some of them we might even recognize the cases and what happened, right? And we're looking at hundreds and hundreds of millions of dollars of settlements here. Now we're just going to take a look at this list and think about this. We're going to pause here. So this settlement, and Greg alluded to in the very beginning, right? This is settlements of cash. This is cash in derivative cases, right? Now, in most states, this is non-indemnifiable loss. Okay, so we're going to get back into that in a second, but just remember this is non-indemnifiable loss, and this is cash that goes back to the company, right? Cash settlements funded by D&O insurance, right, paid to the company on behalf of the individuals for their alleged wrongful acts that harmed the company, right? Greg mentioned in the very beginning, that's the nature of a derivative suit. And this is kind of, if you think, well, hey, that's a circular payment, I agree. It's a circular payment. So look at so these companies were paid, right? Madison Square Garden, 85 million bucks. CBS, 165. Does Goldman Sachs need $79.5 million? There we are. So let's kind of move on. Let's go over to the next slide and talk about how we can sort of identify some of these cases and how this kind of develops. So from the damages perspective, some of us are familiar with damages calculations in 10b5 cases and derivative cases. There's no mathematical calculation. I want to talk about a 10b5 case. It's pretty straightforward, right? We've got a stock drop. We multiply it by the outstanding shares. We got a market cap loss. We got our experts to slice and dice. What are the trades in and out? What's the disaggregating information? And we can really get that damages number mathematically down to literally a science. That doesn't happen here in derivative cases, right? To me, in my opinion, there's a major subjectivity element to these kinds of settlements. And when we look at that subjectivity, what are we looking at? We're looking at what's this company? How big are they? What's their notoriety? Now, we just looked at all that list. We all recognize those cases, right? And here's the big one. What's the shock value associated with the event-driven litigation that led to this case, right? Some of those cases, the shock value is high. Plane crashes, horrible. Opioids, horrible. Wildfires, sexual misconduct. All of those cases had some sort of major event that drove litigation. And in some of those cases, there wasn't even a 10b5 case associated with it. So in McKesson and in Boeing, there wasn't a 10b5 case. It's just a straight derivative because the company didn't lose any money because of that major event. But here we are paying these companies back in a circular fashion, those funds. So what are some of the areas of concern, right, that could lead to large settlements? And how do we figure that out? So in the case of M&A litigation, right, are there conflicts of interest at the board level? Well, there certainly was when Elon Musk tried to buy his cousin's solar company. Well, that case settled for $60 million, right? Was the diligence clean in this M&A deal? Well, it wasn't in Freeport, where errors by Credit Suisse in the financial modeling led to a $138 million settlement. So then we started to look at away from this merger stuff and look at the core business practices of the company. Well, the Wells Fargo board, they failed to stop their employees from opening fake accounts, right? Without the customer knowledge, $240 million settlement. Right? In terms of health and safety, right? We just talked about McKesson. Well, they ignored red flags of suspicious orders and blew past two government settlements, $175 million back to McKesson for their opioid stuff. And then we look at PG&E and Boeing and Blue Bell Creameries. These people ignored safety concerns, failed to oversee mission critical aspects of their business for devastating results. All coming back from a shareholder perspective, money back into the company. And of course, there's always fraud, right? We're always suspect of fraud. We can't help it. American Realty, right? The board ignored this market manipulation, and the CFO actually went to jail. Nobody goes to jail. This guy went to jail, so you know he did something really, really bad, right? So as I kind of wrap up my piece here, right? My sort of thought, governance and oversight, right? Just have to secure their mission critical aspects of their business, right? Through strong governance and close oversight. And you've got to find the board conflicts, that M&A stuff, because honestly, if you don't find them, the Delaware Chancery Court will absolutely find conflicts. So you've got to be ahead of that. And in my personal opinion, and I'm going to close with this, you need help identifying these things. You need help with your governance. Hire this team at Seyfarth, right? And they'll help you on the front end, or else they're going to help you on the back end. And you'd rather have them help you on the front end. Thanks very much.
Greg, I think I'll go ahead and give the CLE code just in case people have to jump since we're at the top of the hour. Is that okay? It's SS4174. That's S as in Seyfarth, S as in Seyfarth, 4174.
Are you?
I'm
You're
all
done?
set.
Okay,
Yeah.
so let me, anybody who's still on the phone, probably there's a bit of an exodus once the CLE code was given. I do want to mention that there is a somewhat more detailed and lengthy, what I'll call flip book, which Sadie, who was on at the beginning of the call, and Nicole Bandemer put together. And it is very interesting, and there are some additional points made there that we didn't have room for in today's time frame. So I encourage you to we're providing that at no cost, the flip book, and I encourage you to take a look through the flip book. We will attempt to answer any questions that have been sent in. And finally, we have a list of practical takeaways for the board. I think it's a little bit, according to my watch, we're after 2 o'clock Eastern time, and I'm not going to take up your time online to go through them, but the practical takeaways are in the flip book, and I think you can literally flip through the book and look at the areas that you are interested in that maybe we didn't have a time to finish. One of them would be the practical takeaways. For board members and officers who happen to still be on the phone, the flip book will provide our views and advice on practical takeaways from the current state of play in derivative litigation and I think you'll find that interesting, but there's a lot more interesting in the flip book. I want to congratulate both Sadie and Sadie and Nicole. They did a great job on putting the flip book together. And finally, I would like to say I'm very proud of my panelists today. I think they did a great job, and I hope you all out there enjoyed the presentation. I thought it was excellent throughout. Thank you so much for listening, and we're going to sign off.